virtually would please remain muted and use the raise hand feature in Teams to be acknowledged. A moderator has been assigned to unmute, allow public entry, and remove attendees if necessary. Good morning, residents of our Commonwealth and everyone in attendance. I'm Krista Caceres, Chairwoman of the Citizens Law Enforcement Advisory Review Commission, and want to welcome you to our third quarterly meeting. It's Monday, September 23rd, 2024 at 10:07 a.m. This meeting is officially called to order. We will now have roll call of our commissioners and ascertainment of quorum by Commission Secretary and fellow Commissioner Amy Zapp Esquire. Good morning, Secretary Zapp.
You're muted. There you go.
Good morning. I know I just wasn't fast enough. Yes. Thank you so much. And we'll begin with Madam Chairwoman Krista Caceres.
Present.
David Sonnenschein. I think David is muted.
Present, sorry.
Jeffrey Wilson.
Present.
Leon Ford. I believe he's absent.
He is absent today.
Jack Roselle.
Present.
Benjamin Lerner. I don't see him up on the screen. I'll come back to him. Francis Chardo.
Here.
Charles Bailey.
Here.
Kevin Mahoney.
Here.
And for the record, I'm here too. And again, I'll ask for Benjamin Lerner. I don't see him, so should we record him as absent, or do you think he'll be joining us?
He may join us later, Secretary Zapp, so we will go ahead and conclude the roll call. And it appears we have seven commissioners in attendance and 2 absent at this stage, correct?
That correct.
Okay, so seeing that we do have a quorum, we may proceed with necessary votes on official business. Before we officially begin, I would like to acknowledge and thank State Inspector General Lucas M. Miller, Ms. Jamie Hicks, Executive Director of the Clear Commission, Ms. Corey Thurl, Assistant General Counsel for OSIG, and Mr. Jonathan Hendrickson, Deputy State Inspector General of External Affairs for OSIG, for their continued hard work and guidance on our behalf. Next, I would like to acknowledge and thank the ex officio members who are with us today for their partnership and for their service to our Commonwealth. First off, representing the Office of Governor, Deputy Chief of Staff, Michael Pipe. Good morning. You are welcome to speak if you would like.
Okay, thank you, Chairwoman. I appreciate the opportunity just to address the Commission for a brief moment before you get underway here. For all of you, it's been almost a year, if not a little bit more, when we first started having conversations about the Clear Commission, and really just wanted to take a moment to recognize all the work that's gone into the recommendations you will be voting on today. And one of the things that we impressed upon you, and the governor did as well, when appointing you all, was to encourage there to be vibrant and respectful dialogue about these conversations related to the recommendations, and was really looking forward to having recommendations that these agencies could adopt, review and adopt, and be mindful about how they would go about implementing them. Or if they would choose not to implement them, to have a very robust response in why they are not implementing these. And so just wanted to encourage the commissioners to have a robust conversation about the recommendations today. The governor's office certainly does not expect you to be unanimous in your recommendations. Dissensions are certainly welcome. But we also appreciate and understand that the covered agencies may choose not to be unanimous in their response and implementation of these recommendations. However, we do expect them to have an extraordinarily well-reasoned assessment on why they will not be implementing the recommendations. So we certainly look at this as a two-way street of constructive and collaborative conversation, but ultimately we're really focused on the progress that can be made for improving these agencies and challenging them to potentially rethink how they do things. So just want to, again, thank you for your work. Really appreciate the importance of this commission. And from the governor's office, again, thank you for your continued service, and also to the team that supports you as commissioners, from IT to legal to admin. Really appreciate the work that happens there to empower you all to have these conversations today. So again, thank you very much.
Thank you very much, Mr. Pipe, and please give our regards to the governor. Next up, representing the General Counsel Jennifer Selber, and the designees Executive Deputy General Counsel Kelly Sekula and Deputy General Counsel Ann Gingrich Cornick, who I believe are attending virtually.
Yep.
Good morning. Would anyone like to speak on behalf of the General Counsel? Okay, moving on. Representing Pennsylvania. Good morning. I apologize.
No comments. Thank you very much.
Thank you so much for being with us. Representing Pennsylvania State Police, the ex officio member is Colonel Christopher L. Paris. The designees, Major Jonathan Rush and Major Peter Gutowski cannot join us today. However, in their absence, we have a few members from PSP's Internal Affairs joining us. Captain Nicholas Cortez, Lieutenant Timothy Janasco, Lieutenant Brandon Forlocker, and Sergeant Elizabeth Klatch. Good morning, everyone, and thank you for being with us. If anyone has any remarks they'd like to share, brief remarks, please feel free to do so now.
Good morning. We appreciate the opportunity to be present today.
We are happy to have you with us today. Thank you so much. Next up, representing the Pennsylvania Department of Conservation and Natural Resources, Secretary Cindy Adams Dunn could not join us today, but in her absence, we have the DCNR designee, Deputy Secretary John Norbeck, appearing virtually. Good morning.
Good morning, and thank you folks for your work on this commission. And you know, the process that we go through, it's a continuous improvement process for not just the agencies that you're reviewing on those days, and I know you know that, but the recommendation that you make each time is reviewed by all the agencies, and it helps us continue to improve our public service. So thank you very much for that.
Thank you as well. Representing the Pennsylvania Department of Corrections, the ex officio member is Secretary Dr. Laurel Harry, appearing virtually. Good morning. Oh, appearing in person. No.
I don't know if she's virtual or not. I don't know if she does.
I apologize. The designee for the Department of Corrections, please forgive me, recently appointed Deputy Secretary for Parole Field Services, Deborah Carpenter, who is appearing in person. Good morning, and thank you for being with us.
Thank you.
And I do not believe the Chief Jacob from the Capitol Police is with us this morning. So with that, we will go ahead and move on. We do have one matter of business that requires a majority vote, and that is to adopt the minutes from our June 17th, 2024 meeting. The minutes were distributed to all the commission members and ex officio and designees prior to this meeting for review. May I have a motion from the commission to accept the minutes for June 17th, 2024?
So moved.
I did get a motion from Commissioner Wilson. Is there a second?
Second.
Okay, I got a second from Commissioner Mahoney. Any questions or discussion before we move to a vote? Hearing none, all in favor?
Aye.
Any abstentions or dissension? Okay, hearing none, the minutes have been adopted. Thank you so much. Next, I'm pleased to announce that the Clear Commission has completed the first round of case reviews for our 3 designated committees as outlined in our executive order. As previously mentioned, the Governor's Executive Order 2023-21 provides for the process by which the Clear Commission will follow under Section 4, subsection 1A through C. The commission is authorized to review covered agencies' completed internal investigative findings related to allegations of use of force and bias-based policing. We review events, policies, practices, and procedures, and make recommendations to correct any perceived policy or training deficiency when and where appropriate for covered agencies following the completion of a case review. The Bias-Based Committee is charged with reviewing all investigations related to allegations of racial or ethnic discrimination and other bias-based policing or external complaints of bias or discrimination during interactions with covered agencies' law enforcement efforts. The committee members of the Bias-Based Committee are Commissioner Caceres, myself, Commissioner Vice Chair Sonnenschein, and Commissioner Bailey. We will now hear the committee's case review, which will be delivered by Committee Chair Kevin Mahoney. Good morning.
Good morning. Thank you. I'm going to try to summarize this briefly.
No, take your time
Okay.
and.
So this case came from the Department of Corrections Field Services Division. A brief summary of the complaint. In December of 2021, a third-party complaint was received via email from a re-entrant. Re-entrant is basically the person on parole, formerly known as parolees. So the re-entrant's girlfriend alleging harassment was being perpetrated against him by the patrol agent. They cited examples such as the agent contacting his employer to inquire about locations, accusing the re-entrant of providing the wrong phone number, and contacting the re-entrant many times via text messaging. The email was routed to the Bureau of Investigation of Intelligence. The agent contacted the re-entrant's, the executive assistant reviewed the case notes and took note of recent travel violations by the re-entrant. It turned out the re-entrant had been traveling without approval, which was the purpose for the employer being contacted. As a result of these violations, additional restrictions were placed on the re-entrant, leaving the halfway house, but he was permitted to go to work. The re-entrant was interviewed, and he expressed frustration with the GPS and travel permissions, but understood the conditions imposed. The executive assistant gave the re-entrant contact information to the district office for any future concerns, and also provided her a direct extension. On December 13th, 3 days after the first complaint, a second complaint was received from the re-entrant's girlfriend and followed up. The follow-up was conducted and no issues were reported. And the case was closed on December 13th, 2021. So in the review committee found that the internal investigation was prompt. The complaint was addressed quickly and resolved in less than a week in accordance with the existing policy 1-3-2 citizen, legislative, and executive office inquiry. The committee also found that the investigation was fair and impartial. The agents were responsive and respectful to the involved parties and provided direct contact. Additionally, the investigation findings were reasonable and in accordance with appropriate protocol. Some issues that were raised during the review: was the investigation complete and performed according to existing policies? The Department of Corrections did inform the review committee that there is no specific manual or policy for internal affairs or administrative investigations regarding parole field agents. And the current process that was in place was resulted from the merger between the Department of Corrections and Parole Field Services. The DOC did acknowledge that the policy and procedures required updating. The investigative findings provided to review were not in a report format. It was primarily consisted of copies of email correspondence along with the case file review and a one-page timeline. Another issue that was discovered was that there was no documented or verified interviews with the complainant or the re-entrant. Review of the Department of Corrections Policy 6.3-1, Bureau Investigations and Intelligence Investigative Procedures, indicates that all interviews should be audio recorded and written statements shall be provided at the end of interviews, and audio or written statements shall be made attachments with the case management system. A secondary concern raised by the review committee during the case of this review was the methodology by which the DOC classifies incoming parole field services complaints. While this complaint was classified as a bias case, the complaint filed did not contain any allegations of discrimination or bias by the patrol agent on any specific characteristic of the re-entrant. This lack of clear criteria when categorizing the nature of complaints involving field services staff can be problematic for the department, the public, and subjects of the investigation. Also, the committee found that the lack of standardized reporting policy and manual was concerning, given the scope and size of the parole field services. This consists of approximately 700 agents and 32,500 reentrants. Several recommendations were made by the committee. The first recommendation would be a clear policy statement that defines the agency's internal affairs investigative process, purpose, and who is covered. The second is a definition of key terms, including clear parameters for the assignment, categorization, and prioritizing of internal investigations. Standard definition of what constitutes bias-based policing should be included, consistent with best practices. Third recommendation was standardized reporting templates, a list of investigative requirements, and the method by which investigators are assigned. Number 4 is a detailed complaint processing reporting procedure for both citizens and reentrants. Number 5, requirements for verification, memorialization of interviews and statements. Number 6, define the rights of both complainants and the accused, of course, in accordance with applicable collective bargaining agreements, and define all possible outcomes of the investigations. For example, sustained, non-sustained, unfounded, policy void, etc. That concludes the summary of the investigation.
On behalf of the Commission and the Commonwealth Chair, Mahoney, we just thank you for your leadership in leading this committee and for providing a detailed and thorough case review for the public and the covered agencies. With that, I would like to open it to our commissioners, both here and virtually, for any comments before we move to a vote following public comments. The floor is open. Seeing no one wishing to offer any comments on behalf of the commission, we will now open it up for public comments on the case review. If there are any, if you're here virtually, please use the raise your hand feature and you will be allowed to speak. Seeing that there are no public comments for this particular case review for the bias-based committee, we will move to a commissioner's vote on acceptance of this preliminary case review. All in favor?
Aye.
Aye.
Any opposed or any abstentions? If so, please state your name. Hearing none, this preliminary report on behalf of the bias-based committee has been adopted. Thank you very much. Next up, the use of force committee is charged with reviewing a representative random sampling of lower level uses of force resulting in injury or death, including arrest and control techniques, baton strikes, and conducted energy weapon deployments. The committee members of the use of force committee are Commissioner Wilson, Commissioner Chardo, Commissioner Mahoney, and Commissioner Roselle. We will now hear the committee's case review delivered by Commission Vice Chair and Use of Force Committee Chair, David Sonnenschein. Good morning.
Thank you, Madam Chair. Facts, I will review quickly. You all have them in front of you at a little more length. Christmas Eve 2021, a PSP trooper was dispatched to assist local police. No local police department member was available. The trooper was dispatched at 9:28, and to the credit of the trooper, arrived within 5 minutes, and the trooper was there by himself. What he found was an adult female, we'll call the victim, and her mother were outside the residence when the trooper arrived. The adult male, who became the defendant, was intoxicated, disorderly, and combative. And the reports the trooper received before arriving on the scene were that he was physically assaulting, abusing the victim, his wife. The victim and her mother were on the street talking to the trooper. The trooper spoke to the defendant and asked him to stay on the porch, not to come out and approach either the trooper or the victim or her mother. and the victim and the defendant continued to be aggressive and threatening, and then approached the trooper and the victim, leaving the porch, escalating the situation. The trooper felt the defendant was a physical threat to himself and to the victim, and stepped between the defendant and the victim to protect the victim. The aggressive defendant continued to approach, and the trooper pushed him in the chest area to create some distance, what is called a reactionary gap. And in doing that, the defendant fell backwards toward the porch. At this point, the trooper told the defendant he was under arrest. The defendant actively resisted, refusing to comply, thrashing around, yelling obscenities at the trooper, and the trooper was eventually able to handcuff him. In the course of trying to turn him around and handcuff the resisting defendant and gain compliance, defendant struck the face of the defendant struck his face on a brick pillar, injuring his nose. Once the trooper was able to successfully handcuff the trooper, he placed him in a chair on the porch, observed the injury, and immediately sought medical care. And then an officer from municipal force appeared on the scene to assist. Again, the trooper continued additional investigation and found there was a domestic assault, as he had assumed or heard. Fresh injuries on the victim's neck and face. Apparently, the defendant had been trying to choke his wife before the trooper arrived. The defendant was then transported immediately to the PSP station, and the trooper then notified the commander, the shift supervisor. After initially refusing medical care, the defendant was eventually persuaded to accept medical care. He was medically cleared, transported to jail, subsequently arraigned on the following charges: strangulation, obviously with respect to the victim, his wife; simple assault, harassment, and resisting arrest. That night, or the next morning, I should say, December 25th, Christmas Day, the blue team entry was entered and the investigation began and went up the chain of command, all appropriately done by PSP. And in the end, the use of force utilized by the trooper against the defendant was ruled to be justified. And this trooper was eventually returned to duty. We reviewed all of the reports, all of the investigations. Witnesses were interviewed. Their witness statements were in writing, etc. And apparently everything available to the PSP investigators was reviewed and considered. We found that there was after reviewing the field regulations of PSP on use of force and on de-escalation, we have no recommendations for those policies. And we examined extensive educational materials, procedures the PSP utilized for de-escalation training for its members, with which some of us are actually have seen in practice and are familiar. And we have no further recommendations with respect to de-escalation, which seem to be followed by the trooper in this situation. We have only really one recommendation. Let me make one other point before I go to the only recommendation we have. This complaint on use of force was initiated by PSP. There was no complaint by the defendant, by the person who was subjected to the use of force. So this was an internally developed investigation. And again, I mentioned a moment ago that PSP and the investigators did a very thorough investigation, appeared to look at everything available, and relied on that in making their recommendation. The only issue that we have by way of a recommendation is this. When there is a citizen-initiated complaint of use of force, PSP policy and practice goes the same kind of interviewing we saw in this case, but also approaches the quote unquote victim of the use of force and offers that person a chance to be heard and make whatever statement he or she likes. In the case of self-initiated, that is investigations like the one we're looking at here, there is no policy or requirement that in the course of the investigation, PSP investigators will approach the defendant to get, if you will, his or her side of what happened. The rationale for that makes a whole lot of sense. Obviously, this person who is going to be a criminal defendant has constitutional rights and certainly can't be compelled to speak to the PSP investigators. And in fact, 99% of the time, I suppose, his or her attorney would not permit that person to speak to the PSP investigators for fear of incriminating himself, herself, etc. And respectful of that, being respectful of that apparently is the reason why PSP, unlike in the citizen complaint initiated situation, does not approach the defendant to get his or her side. Our only point, and the point of our recommendation, is this. We assume, of course, the counsel may well not permit the defendant to speak to PSP. We certainly get that. I've taught criminal procedure for 40 years, and I totally understand that. And I think our subcommittee does as well. But we thought in the interest of comprehensive investigation that we think it would probably be a good policy for PSP in a self-initiated complaint, as we have in this case, to still approach through counsel, not the defendant himself, because that would be inappropriate, but approach counsel for the defendant to see if counsel and the defendant would like to be involved and make any statement that might, make the investigation, if you will, complete and more comprehensive. Again, we are not Pollyannish about this. We know that 99% of the time, counsel, that may be less than 99, maybe 95% of the time, counsel will probably advise his client not to talk to the investigators. But I think it would be good if we can get everybody's side to be able to be confident that we have the entire picture of what happened. We have no quarrel with the investigation that was done in this case. We have no quarrel with the information that was developed by PSP, but we thought this would be a good policy recommendation for future cases. In the case, I think particularly where there might be a one-on-one situation, that is one member, one trooper, and perhaps one suspect / defendant. Here, there were plenty of other witnesses. All were consistent. And so this, I don't think, was a big issue in this case, but there could be situations where it might is the key here, make a difference. And so that is our only recommendation. We find that the investigation was complete, fair. The finding by PSP investigators and the people up the chain was reasonable. The investigation was prompt, fair, impartial, complete, and all done in compliance with appropriate PSP policies and regulations. So that's our only recommendation.
Thank you, Vice Chair Sonnenschein, and to you as well. Thank you for your leadership and work on behalf of the Use of Force Committee, and thank you to all of the members for your service. With that, we will open the floor to the commissioners for comments related to this particular case review.
Nothing to add on the case review, but I did want to note that Judge Lerner had joined us earlier and was here for the not long after the roll call, so we have a supermajority.
I noticed it too, and I was just going to say I'm going to adjust the attendance sheet accordingly.
That's excellent. Well, thank you, Commissioner Chardo, for noting that, and welcome, Commissioner Lerner. It's good to see you and have you with us.
He's muted, I can see.
And we'll carry on. So again, we will open the floor for any comments related to the use of force case review by the commissioners. Hearing no comments from the commissioners, we will move on to public comment. Anyone that wishes to comment from the public on this particular case review, please raise your hand to be recognized. Seeing no raised hands by the public, we will proceed to a commissioner's vote on acceptance of the use of force preliminary case review. All in favor? Aye.
Aye.
Any opposition or abstentions? If so, please state your name for the record. Hearing none, the use of force preliminary case review has been adopted by the commission. Thank you.
Thank you.
The Critical Incident Committee is charged with reviewing all investigations of police-involved shootings resulting in injury or death of civilians by covered agencies. The Critical Incident Committee members include Commissioner Ford, Commissioner Lerner, Commissioner Zach, Commissioner Bailey, and Commissioner Chardo. As chair of this committee, I will deliver the case review. It will be slightly more detailed and maybe a little longer than the two prior case reviews, simply just because of the nature of this report. It did involve a police-involved shooting resulting in the death of a perpetrator. So with that, I will begin. The report number is CI 1-2024. The incident date is December 26th, 2021. There was no criminal disposition. The agency administrative disposition, the use of deadly force, and the deadly force authorization was justified. Adjudication was approved by the Deputy Commissioner of Administration and Professional Responsibility. We reviewed 6 relevant policies and additional criteria during the process of this case review, and the preliminary findings and conclusions are as follows. Brief summary and statement of facts. On December 26, 2021, PSP troopers were dispatched at 10:23 p.m. to a disturbance in a home involving a firearm after a 911 call. An adult female victim entered her residence and found her adult brother unlawfully inside, intoxicated, and in possession of a firearm. While engaged in a disagreement over an inheritance, the subject pointed a firearm at and threatened to kill the victim. The victim fled the residence and contacted a relative, who in turn contacted PSP by calling 911. Patrol troopers arrived on scene shortly thereafter, established a perimeter, and attempted to hail the subject from the residence, a single-family home. Over the course of several hours, troopers also contacted and negotiated with the subject via telephone and Facebook Messenger, but he refused to surrender. While the negotiations with the subject continued, an arrest warrant was obtained for the subject on the charges of several that I will not name now, and a search warrant was also obtained for the subject inside the residence. At approximately 2:45 a.m., CERT members took over the perimeter and established their positions. The armed subject subsequently exited a rear door with an object in his right hand, began scanning the area, and then re-entered the residence. Due to a lack of cover and concealment, CERT members felt their positions were compromised, causing them to redeploy to different locations on that perimeter. Trooper 1 repositioned himself to visually cover the residence and had a direct line of sight of that rear door. During ongoing negotiations, a clear and concise surrender plan was given to the subject. At 3:37, the subject was online with negotiators when he saw troopers on the side of the residence. The subject further related he would shoot the next trooper he saw. This information was relayed to the CERT members on the perimeter. The subject then exited the rear door with a firearm, pointing it towards CERT members. Trooper number 1 subsequently fired 1 round from his department-issued rifle, striking the subject. The subject fell to the ground, still maintaining possession of the firearm. Trooper 1 began issuing verbal commands to the subject to drop the firearm and crawl out of the residence. The subject leaned back up and scanned the area with his firearm, pointing it directly at Trooper 1. Trooper 1 subsequently fired 1 additional round, striking the subject, causing him to fall backwards into the threshold of the door. The subject was not reacting to verbal commands nor the deployment of a noise flash diversionary device. CERT members then approached and secured the subject, and tactical paramedics rendered aid. However, the subject succumbed to his injuries on scene. The county coroner responded to the scene and pronounced the subject deceased. A major case team activation was initiated to investigate the incident. 2 internal affairs division members, state police sergeants, responded to the scene, completed and witnessed the weapons download, and gathered other relevant information for the investigation, including crime scene analysis. On the same day, December 27th, Trooper 1 was placed on administrative duty status and a blue team entry was submitted for firearm discharge and assigned as a full administrative investigation. On February 24th, 2022, the county district attorney provided a prosecutorial determination. There was no evidence of any crime committed by Trooper 1 after reviewing all the evidence concerning the use of deadly force and the subsequent death of the subject. Following the receipt of the prosecutorial determination, an IAD administrative investigation commenced. On February 25th, 2022, Trooper 1 was returned to full duty status. A comprehensive IAD investigation was completed on April 8th, 2022, and sent up the chain of command. On May 11, 2022, the division director provided correspondence that the incident and all investigative documentation was reviewed, and the use of deadly force by Trooper 1 and the deadly force authorization were justified. On June 1st, 2022, this investigation was closed by IAD. This committee's preliminary findings and conclusions. The commission found that the internal investigation was indeed prompt and complete as outlined within Administrative Regulation 4-25, Internal Investigation AR 4-25, and in accordance with the PSP Collective Bargaining Agreement. The IAD investigation was initiated promptly via blue team entry on December 27, 2021, and adjudicated as required within 90 days of the completion of the district attorney's prosecutorial determination on February 24, 2022. The review committee finds that the IAD investigator collected all relevant facts, reasonably obtainable, and conducted all relevant interviews. The committee found no concerns related to fairness and impartiality as with respect to the completed internal investigation, and was also found to be free of any conflict of interest based upon the summary and statement of facts and additional documentation submitted. Additionally, the findings were reasonable and in accordance with the applicable protocol. This commission, upon review of this particular case, do have 2 recommendations for corrective action. Number 1, the commission recommends an amendment to Field Regulation 1-5, officer-involved shootings/serious incidents under Section 5.06, subsection E, return to full duty status. I will not read the full wording in Section 5.06, but essentially, a member or enforcement officer placed on administrative duty shall be returned to full duty upon the order of the Deputy Commissioner of Administration and Professional Responsibility after evaluation of the following, and there are several for consideration when making that determination. Currently, a member or enforcement officer can be returned to full duty status prior to the completion of the IAD investigation after the above requirements have been satisfied. In 21-1860, that was the case that we reviewed, the prosecutorial decision was rendered on February 24th, 2022, and Trooper 1 was returned to full duty on February 25th, 2022. IAD began their investigation on February 25th, 2022, with an adjudication issued promptly on May 11th, well before the 90 days required for completion had elapsed. The review committee recommends that Section 5.06, subsection E of FR 1-5 be amended to require that a member/enforcement officer placed on administrative duty shall be returned to full duty upon order of the Deputy Commissioner of Administration and Professional Responsibility following the completion and full review of the IAD adjudication and investigation. And the rationale for that is because subsequent discovery by IAD may reveal or produce evidence that was not available to the district attorney at the time of their determination. The second recommendation is the commission recommends adding a provision to Field Regulation 1-5, officer involved shootings / serious incidents under section 5.07 reporting. Section 5.07 states, an involved member / enforcement officer will not be required to author any supplemental criminal report. However, an involved member / enforcement officer is required to adhere to the provisions of AR 4-25 Administrative Regulation. AR 4-25, Section 25.09 states that IAD investigators will ensure that the subject of an administrative investigation is personally interviewed. Additionally, subsection C 14 requires all department personnel interviews conducted during an administrative investigation are recorded. The review committee notes there were multiple provisions within the Field Regulation 1-5 that detail how information is obtained from that involved member or enforcement officer following a serious incident or an officer-involved shooting. Appendix J requires the involved member to immediately provide information for a public safety statement, which is a brief factual account to establish the level of danger that may still exist at the scene or in the community, aid the initial police response, and focus that preliminary investigation. Further, once a public safety statement has been obtained, no additional information shall be sought by means of direct contact with the involved member or enforcement officer. Should additional details beyond those contained in the public safety statement be required, a request for this information shall be made via the attorney representing that involved member. The review committee does recognize that AR 4-25 and the above listed provisions outline methods of acquiring and preserving the involved member's recollection of events. However, the review committee recommends members involved in critical incidents should be required to provide a written statement to gain a complete timeline of the events that led that member or enforcement officer to make his or her determination related to their use of force. The review committee further recommends that any written statement or interview verification from the involved member or enforcement officer be obtained consistent with existing policy, and that such a statement is taken 72 hours following the incident and with the assistance of legal counsel. Therefore, in closing, the committee recommends a provision be added to Field Regulation 1-5, Section 5.07, that requires the involved member / enforcement officer provide a signed written statement and or a signed verification of the criminal and administrative reviews for the investigative record. That concludes the review of the Critical Incident Committee. And I would like to commend the members of the committee for your hard work, your thorough review of this detailed case, and spirited debate throughout. So with that, I would like to open the floor for any commissioners to add comment to the recommendations or the review itself. If you are virtually, please feel free to use the raise your hand feature and you will be acknowledged to speak.
I was just going to note, I think there's generally a tendency to conflate the review by the DA and departmental review, whereas they are different analyses. Whether or not something violates the criminal law and whether or not it is violative of procedure of regulation, there are two separate questions. And so just because something passes muster and is not, the DA says, well, there's no violation of the crimes code here, doesn't mean that it's necessarily a good use of force, because there may be a violation of procedure. So there are two separate analyses.
I do agree. Thank you, Commissioner Chardo, for that. Yes, sir. Commissioner Mahoney, hi.
Hi, Commissioner Mahoney here. A few things, I respectfully disagree with, the waiting for the IAD to be complete.
Mhm.
As you can see, there is a plethora of clearances that are made before the member is returned to full duty. The second, I just have a question. I read this last night. I didn't catch this the first time I read it. It says the review committee recommends members involved in critical incidents should be required to provide a written statement.
Mhm.
Now, and then it goes on to talk about, going to take into account the 72 hours that we give to officers.
Mhm.
My question is this written statement, part of the criminal investigation?
It could be either, and so we're not making that determination, we're simply, or making that a sticking point. We're simply saying that when an involved member or administrative officer is going through that process, whether it is a transcript of the recorded statement that they make, that they sign, or they actually write out a timeline of events, it's kind of one and the same. But having that involved member or officer sign such a statement is ascribing that they agree that this is their recollection of the timeline that led to their consideration.
And I didn't catch that before, because that, I mean, that is the practice now, is for the most part, it is being recorded, you know, it is.
Correct.
And so I'm just wondering, do we need to have it transcribed and then signed after the fact, or is that delaying things unnecessarily? Because we are fortunate in Pennsylvania that the recording has the same effect in any courtroom as a signed copy. It can be used as substantive evidence if somebody says something different. Just a thought.
Yeah, and I respectfully received that, but I would also submit that again, videos can be edited. There could be situations where someone could then dispute whatever is presented as a recording. And so again, when you're pulling a transcript, that this is a written recollection, just like if, you know, not trying to equate the two, but if we're talking about criminal process, anytime someone is brought in, right, as a suspect, and they plead guilty or whatever the process is, they have to sign a written statement, you know, saying this is, right, what my recollection of events are. This is in my own words, what happened.
Actually, in Delphi County, they don't sign, well, they sign the back of the information, but it's.
Is that not the same
it's
though?
court reporters.
Correct. And so I'm saying a transcript, right, which is essentially a recording of a written version, a written transcript, or written transcribing of that video is essentially the same thing. But thank you.
Madam Chairman, may I respond for a moment to Commissioner Mahoney's question about
Yes.
what the purpose of this? I would assume that requesting the statement from the involved officer is only for purposes of IAB, the IAB investigation. We can only control that, and we would certainly have no opinion or no ability to require to include that in the criminal investigation, and that's not within our remit. So in his question, I think the only reason we're seeking this is for purposes of the internal investigation.
Thank you, Vice Chair. And to that point, I would like to further submit that kind of ties up the second request that we're making, or recommendation that we're making, with respect to the requiring or allowing the completion of the IAD investigation before returning a member to full duty status. For that reason, things may develop at any point, right, during either investigation, which would put into question a return to full duty. Not that there would be, but we just feel allowing for a full 90 days for that process to play itself out, if necessary, to allow both sets of investigations to be completed would give the people of the Commonwealth full confidence in what has occurred as far as the shooting has or injury, shooting, injury, or death is concerned. Any other comments with respect to this particular case review? And I thank everyone who has offered comments thus far, and I appreciate the purview. Hearing none, we will go ahead and move to public comments. If anyone from the public has a comment on this particular case review, please use the raise your hand feature and you will be called upon to speak. Seeing no public comment waiting, we will go ahead and move to a commissioner's vote on acceptance of the Critical Incident Committee's preliminary case review. All in favor?
Aye.
Aye.
Any opposition or abstention? If so, please state your name for the record.
Mahoney. Respect.
Okay, opposition?
Yeah.
Okay, just making sure it wasn't abstention, okay. So we have,
I'm sorry.
And Bailey, respectfully.
Yeah, I'm gonna abstain, just because I don't like the one part, but I'm gonna abstain.
Okay, so we have an abstention from Commissioner Chardo and opposition from Commissioner Mahoney and Commissioner Bailey. Anyone else? Okay, based on my math, I believe that the preliminary case review has been accepted and the two oppositions and 1 abstention has been noted for the record. I do appreciate this discussion, and I thank you all for it. Just to provide additional information following the votes on the 3 committees' case reviews, before a report is considered final, the preliminary report and any recommendations within that report must be approved by a majority of the voting members of the commission, which has occurred, and the covered agency must have had an opportunity to respond to the report. A covered agency has 60 days to respond to a preliminary report and provide the commission with a written response, including what, if any, recommendations it may implement, or an explanation if proposed recommendations cannot or will not, be implemented as prescribed by subsection B4 of Executive Order 2023-2021. Any questions about what happens next? Okay, so now that we have concluded the case reviews, again, I want to thank every member of the commission for your work. And now we will open the floor for general public comment at this time. The floor is now open for public comment. Please utilize the raise your hand feature and you'll be recognized to share your thoughts with us. If anyone has any public comment, please state your name, city, and state, and limit your comments to no more than 2 minutes. All right, seeing no public comment waiting. On behalf of the Clear Commission, we would like to thank everyone for joining us. With no other business to consider, I would like a motion to adjourn.
So moved.
Thank you. I got a motion from Commissioner Chardo. This meeting is adjourned for Clear at 10:58 a.m. Thank you all for your time.
Thank you.
Thank you. See you, everyone.
Bye, everybody.